answered by our experts, the attorneys with Josh Wright from the Hollis, Wright & Couch Law Firm, and host David Lamb.
Hello and welcome into the attorneys. I'm David Lamb. Appreciate you being with us on this Sunday evening. Our topic of conversation is one that affects a whole lot of folks, debt collection and bankruptcy. We have a panel of experts here to help guide us through this conversation. And if you'd like to participate, ways for you to do so will be displayed on the screen. Josh Wright of the firm Hollis, Wright & Couch leading the discussion for us. Good to see you, sir.
You too. Hope you had a great week this week. Glad to be back again this week. You know, unfortunately, bankruptcy and debt collection is an issue that is facing a lot of folks in our state and our viewing audience now. We wanted to bring an expert on that handles these types of matters and kind of address the topic to give people a view of what their options are under circumstances where they may be overwhelmed with bills or something else. And so we brought Ted Stuckenschneider on. Ted is an expert in this field. Not only is an expert in the field of debt collection and bankruptcy, but he's also an expert in being a professor. He actually teaches on this topic.
I do.
So Ted, we're so excited to have you on the show.
Thank you.
I know people don't like to toot their own horn, but tell us a little bit about what your practice involves and how you're kind of here as our expert today.
Well, for 35 years, I've been in the same location representing people that have been in financial trouble. Try to counsel them on all of their choices, not just bankruptcy, but I am board certified in consumer bankruptcy and Alabama Super Lawyers and Best Lawyers in America for the last 5 years, and I'm a professor at Birmingham School of Law. Teach it.
That's great. Well, thank you so much for coming on today. I know you're going to be able to shed some light on some of this stuff. Let's start from kind of the simplest view of what is bankruptcy. Let's address that issue, and then we'll kind of work our way into some of the specifics.
Well, bankruptcy for individual consumers, which is who we're talking to today, usually is a Chapter 7 or a Chapter 13. A Chapter 7 is a liquidation, and a Chapter 13 is a payment plan. And what happens is if somebody's in financial trouble, then there's several choices they have on how to get out of that trouble. And if bankruptcy chooses to be one of them, then I think they need to speak to an expert to help guide them through it. It's gotten very difficult since 2005 to get through the paperwork. There's that myth out there that you can't file anymore, which is not true. It's still quite available as a remedy.
I had learned before we started the show tonight that there are some 20,000 people that have filed bankruptcy in Alabama just this year alone. So it sounds like it's a pretty significant issue facing a lot of consumers.
It is. Actually, bankruptcies are down about 26% this year. We had more last year, I suppose. But that doesn't mean people aren't in as much trouble. It just means that we're seeing an awful lot of people that even bankruptcy don't help right now. They are just really stymied as to what to do.
Ted, what do you do when somebody comes to your office and says, look, I'm having some financial problems, I'm overwhelmed with these bills? What's your process that you use to kind of walk and lead, guide, and direct them through this complicated period in their life?
Well, the first thing I do is tell them the 3 things that I need them to bring to me: a list of their creditors, a tax return, and proof of their income. When they get to my office, I tell them, I try to calm them down a little bit, because it's usually they're very upset and nervous. They don't want to talk about it. They don't want to be there. They don't like being in that type of a situation. So I try to start out by telling them there are 5 things they can do. They can find more income. They can reduce their expenses. They can file some sort of a payment plan. They can file a straight Chapter 7 bankruptcy where they erase their debt, or in some cases just do nothing at this time, and that's what we're seeing a lot of. And I talk them through that process and try to let them know that I'm going to be with them not only at the beginning of the process, but at the end, and work out a budget to show them that there is life after bankruptcy.
A question we've got here: if I file for bankruptcy, will my creditors stop harassing me?
Yes. Immediately upon filing, an automatic stay is issued by the bankruptcy court, which forbids creditors from contacting the debtor any longer or trying to collect their debt until there's a hearing.
Talk about, if you will, bankruptcy is not the only option, is it?
That's correct.
What are some of the other options that you help counsel folks through?
Well, first of all, we look at their income and see if their income is about to pick up, or if there's something we can do with creditors to say, look, just give them a little bit more time, we can work through this. We also go through and figure out an entire budget to make sure there are no elements that can be reduced there. And then we talk about the different kinds of payment plans. There's debt solution, debt consolidation. There's negative issues there too as well. If you negotiate with your creditors a reduced payment, then you're taxed on the difference as ordinary income. That is something that a lot of people don't realize. And also, it's very hard to get people to take creditors to get a reduced amount unless you can pay them a lump sum. And quite often, folks that come to you don't have money sitting there if they've already been through all of that trying to make things work.
How does filing for bankruptcy, another question we've got, and I'm sure you get this one quite a bit, but how does filing bankruptcy affect a spouse?
That's also very interesting. The spouse, unless the spouse files, then there is no negative impact to that person. However, the spouse can be obligated, let's say on a credit card, in a number of ways. They may have been the original applicant, so they still have to pay the credit card. If I bankrupt on it, my wife isn't free from it. She still would owe it if she's on that same credit card. Or if a duplicate card was issued, that can create the liability as well.
So let's take it from this perspective. Assuming that somebody is so overwhelmed that they're not in a position to be able to use a debt solution group or someone like that, and they have to go to the route of bankruptcy.
Yes.
Is there a different type of bankruptcy? I've heard of Chapter 7, Chapter 13. Can you kind of explain the difference between those two so people understand it?
Certainly. When we go through our analysis, one of the first things we have to do is determine what is the goal. If somebody's behind on their house or behind on their car and they want to keep their house or car, then usually a Chapter 13 payment plan would be the way to do that. We can take the part that they're behind and cure that arrearage. If, on the other hand, it's something they're going to surrender anyway, then that tends to lead them more into the Chapter 7 bankruptcy to get the complete fresh start. Chapter 13 allows the debtor to keep everything and to work out a payment plan, but it goes on for 3 to 5 years in making payments. Chapter 7 is a fairly quick in, quick out, 90 days sort of thing, but you have to give up whatever you have if it's over and above the exemptions in Alabama.
Does it ruin your credit forever?
That's a very interesting question. Everybody asks that question. Anything you do stays on your credit record 7 years. Bankruptcy stays on your credit record 10 years. There's only a 3-year difference there. However, sometimes you're better off with a Chapter 7 bankruptcy than you are being behind on your bills over and over and over again for a number of years. We even have mortgage lenders send people to us that say, look, they've had a foreclosure or they've got such a bad credit score, we'll never be able to sell this person a house. If they bankrupt, then we find they can usually finance a house within 26 months.
That goes right to a question we have here about filing. Would it be better on my credit if I just go to a credit counselor rather than file for bankruptcy?
Well, if you go to a credit counselor and they work out a debt repayment plan, that is going to be an extremely negative mark on your credit for the 7 years instead of the 10. So there's not a whole lot of difference. There is a little, but not enough to really make a difference.
Yeah. All right. Let's take our first break of the evening. As we head to break, a reminder to you, we'd love to hear from you. Ways you can call, text, or email the show. That information right there on your screen. You can also find the firm of Hollis, Wright and Couch. If you'll search that term, find them on Facebook and on Twitter. It's Hollis_Wright. Much more ahead. The attorneys, this conversation on debt collection and bankruptcy. We'll be right back.
I'm Josh Wright with the law firm of Hollis, Wright and Couch, and thanks for watching The Attorneys on Alabama's 13. Now, we hope you, a friend, or a loved one never need legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to this show or related to other civil legal matters, call, email, or text us to talk with one of our lawyers. You can also follow us on Facebook or Twitter to learn about important legal news that could affect you or your family. Or simply contact us by going to alabamas13.com and click on the Attorneys link. We know your time is valuable, so thank you for spending it with us and for watching The Attorneys right here on Alabama's 13.
welcome back into the attorneys. Our conversation tonight, debt collection and bankruptcy. As we make our way through this conversation, ways for you to call, text, email us, and get yourself involved. We welcome that. Interesting, gentleman here, research by the Federal Reserve indicates that household debt in America is at a record high. A lot of folks saddled with a great deal of debt.
Oh, no doubt. And, you know, I can hear people asking this question now, which is, you know, I've already saddled with this much debt. I'm overwhelmed with the bills. How can I afford to go hire a lawyer to help and lead, guide, and direct me through this process? Can you kind of address that issue? Because I think there's a misconception that people can't afford lawyers in these circumstances, and the reality is that they can.
Yes, and first of all, I think it's important to say that they can come and get an attorney's advice for free. Most all of us offer a free consultation. So the first thing that's most important is if you've got a problem, don't sit back and delay. Come and get an attorney and get that free consultation and find out what your choices are, because you could be making some bad steps on the front end without that consultation. But once you determine what you're going to file, if you file a Chapter 13, the attorney's fees are included in out of the payment. So whatever payment you make to the court, the attorney gets his fee out of those payments. So you don't have to have a fee up front usually. There can be some situations where you need a little bit of money to make that first car payment or something at the beginning of a plan. But other than that, you don't need any money up front usually for the 13. In a Chapter 7, you do have to pay the attorney's fee up front. But after you've consulted with the attorney as to which debts you're going to discharge and which debts you're not, then you can start picking and choosing, you know, what you're going to pay and not pay, and maybe be able to save up the fee. If you can't afford a fee, then there are other ways that we can get you through the process. We have a great volunteer lawyers program with the Birmingham Bar Association that we screen people through and get free attorneys for them. So there is a way we'll get you through the process.
A question that we have here, can my boss fire me for filing bankruptcy?
Section 525 of the Bankruptcy Code prohibits employer discrimination, although they can possibly not hire you if they see a bankruptcy on your credit. Once you're employed, they can't fire you because of it.
Yeah. Does your employer sometimes work with the bankruptcy court to make payments, or is that just through a garnishment procedure?
No, they send out a deduction order, and it's sort of like a garnishment, but it does not count as a garnishment on your wages. And the Chapter 13 trustee in Birmingham distributes between $3 and $4 million a month, most of which needs to be brought in by payroll deduction, because it's easier to do that than to open up his own bank, so to speak. And it works just beautifully in Birmingham. It's been here for a very long time. As a matter of fact, Chapter 13 was called the Birmingham Plan, and it was originally founded in Birmingham before it became federal law.
Under what circumstances, talking about the different chapters, question here on Chapter 13, under what circumstances can Chapter 13 bankruptcy be filed?
Well, Chapter 13 bankruptcy is usually filed for somebody who has a regular income. It can include Social Security income. It can rarely, but sometimes include unemployment income. But most of the time it has to be a wage earner or a Social Security regular income.
Okay.
Once we see that they have a regular income, and we have to look at a budget. And if the budget shows, we have to go through and create a household budget. If it shows that they can afford a payment plan, then we try to put one together. Sometimes it's less than 100%. Sometimes it's 50 cents on the dollar or 30 cents on the dollar.
Right.
But all of that is a numbers game that we have to figure out when the client is with us.
Are there, under a 13, are there some things that you cannot go through a 13 and discharge to less than 100%?
Correct. Child support, alimony, certain taxes, and some people don't know this, but some taxes are dischargeable in bankruptcy if they're old enough. But taxes, child support, alimony, things like that.
And let's put that in context. I use the term discharge. When you're talking about taxes and alimony and child support, those are things that if you go through a 13 where you may be able to restructure your debt where you only owe 50% of the debt as to certain creditors, you're not able to reduce those amounts that you owe. Those have to be paid as part of your plan in the full amount.
That is correct. They're considered priority creditors, and they are allowed to be treated differently. All unsecured creditors have to be treated the same. A student loan is an unsecured, non-dischargeable debt. So if you're filing a plan where you're paying 50 cents on the dollar or you're paying no interest to your unsecured creditors, that would work fine for everybody, but the student loan you would still owe interest on after the case is over, or the balance of it after the case is over.
Now, Ted, talk to us about Chapter 7. I know it's different because we're talking about a full liquidation here. Are there some things that you do not have the ability to eliminate as far as debt in a Chapter 7 proceeding?
There are. There are 19 things listed in the bankruptcy code.
What are some high-level issues or some
recent taxes, payroll taxes if you're an employer, child support, alimony is number one, wrongful, if you've hurt somebody or injured somebody in a willful, wanton manner, fraud, embezzlement, those types of things.
And now, I know this is a little off topic, but relevant to our conversation. If somebody is overwhelmed with their bills, they're evaluating a bankruptcy, do they have the ability to go back to the court, for example? I know you were talking about you can't discharge alimony and child support. Do they have the ability to go back to the court and notify the court of the financial condition they're in to try and reduce the amount of child support they have to pay?
Well, that's exactly correct. You can go back to the divorce court with a petition to modify and show what your income is and show what you're having to go through and get that reduction at the same time that you're going through a Chapter 13 payment plan.
And the reason I haven't mentioned that is it seems to me that highlights another reason why you want to come to a lawyer that understands the whole realm of debt collection. It's not just bankruptcy, that's the only option. It is, there are a bunch of other issues you need to take into consideration. Make sure that you're modifying your child support decree if you need to reduce that payment to notify the court that what is going on right now in addition to filing bankruptcy. Am I right there?
You're absolutely correct. And also you need that advice from the attorney as to what to do after bankruptcy. And to get a good budget and a good plan so that you don't fall back into the same situation.
Yeah, you want to restore the credit as quick as you can.
How often is bankruptcy, in the folks that you counsel, bankruptcy not the best option? Maybe someone has lost a job and the calls are increasing, but there's a way out, and bankruptcy is actually not the answer.
I would say half the people that come to see me choose not to file bankruptcy. So quite a number of them ask me, what would I do? And I try not to tell them what I would do.
Right.
I try to tell them what their choices and options are, what the pluses and minuses are for each one, and that way they can make a knowing and intelligent decision just like they were having surgery.
Right. Yeah, time for our second break of the show. One final segment of the attorneys coming up after this quick break. As we head to break, again, ways for you to get in touch with the firm of Hollis, Wright & Couch. Also want to encourage you, if you are on Facebook or Twitter, you'll find them there as well. Stay tuned. More of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis, Wright & Couch. Now, we often hear the phrase burden of proof when it comes to civil or criminal lawsuits. It's the level of proof that plaintiff must meet to win their case. But these burdens change whether you're in a civil or a criminal court. So in this week's Legal 4-in-1, we're answering the question, who holds the burden of proof and what is the burden? Let's start with civil cases. Civil cases are brought by a plaintiff who claims they have been injured in some way by a defendant. Because there is no chance of jail time since the injury does not amount to a crime, the burden of proof is not as difficult as in a criminal case. The level of proof here is called a preponderance of the evidence, and in general terms, that means the plaintiff must prove that it is more likely true than not true that the defendant is responsible for the plaintiff's injuries. Now, you've seen the scales of justice before, and both parties have to fill those scales up with evidence to support their respective positions. And if the plaintiff tips those scales ever so slightly in their favor, they're entitled to a verdict and they win the case. The stakes are much higher in a criminal case than in that of a civil one. That's because a criminal defendant could lose his freedom or even his life if he's found guilty. So who holds the burden of proof in these cases? It's the state, because the defendant is being accused of breaking the law. Now, the state has to prove beyond a reasonable doubt that the defendant is guilty. It's the heaviest burden in the justice system. The evidence has to be so convincing that the jury believes beyond any reasonable dispute the defendant is guilty. Probably guilty just isn't enough. The law, in fact, requires the jury to find the defendant not guilty if there is any reasonable doubt at all. Now, please remember your call, email, or text to the attorneys is free. All of us at Hollis, Wright & Couch want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. And as always, thanks for watching The Attorneys right here on Alabama's 13.
Knowing your rights when facing mounting debt. Welcome back in to our final segment of The Attorneys. As we're into this final segment, want to encourage you to go ahead and get in touch with us. We'd love to hear from you. Interesting statistics you guys always provide. A Harvard study reported that half of U.S. bankruptcies caused by medical bills, oftentimes all kinds of different circumstances resulting in the pressures and the screws being tightened financially.
That's sad. Answer this for us, Ted. Do people lose everything in a bankruptcy, or do you have the ability to keep some things? I mean, how does that work? Because I think that's a question that people are always asking related to bankruptcy.
The bankruptcy code sets out exemptions that people are allowed to keep. However, states were allowed to opt out, and almost all the states did. So the exemptions that are allowed in Alabama, which are fairly low, is what people are allowed to keep. People ask this question all the time, though. Am I going to lose my home? Am I going to lose my car? If you owe money on your car and you stay current on it, then you're usually allowed to reaffirm that debt, continue to pay it, and keep your car. There's usually very little equity in a car. In a house, though, we have a different problem. If you have more than $5,000 per person equity in the house, and the court looks at that a little bit liberally, let's say there's $15,000 equity in a house, you'll probably be okay if it's owned husband and wife. But if you have too much equity in a house, you could lose it if you don't have somebody that can help ante up that difference to the court and reaffirm the debt. But a lot of people have to pick and choose what they want to do and what their whole situation is. Nobody wants to go into bankruptcy. But without the advice of a professional looking at your individual circumstance, it's hard to say what you can keep and not. All retirement plans are exempt.
Yeah, I was going to ask you about retirement and pension plans.
Unfortunately, we see a lot of people that haven't come to a lawyer soon enough, and they've raided their retirement account trying to avoid having to do anything, and then they come to see you, where if they'd come to see you sooner, they could have saved that retirement account.
Yeah, and that's a good point. Let's stay on that just for a moment. What you're saying is, under bankruptcy, if they have a pension or a retirement plan in a plan at their work or that they've maintained, yes, that may not be subject to bankruptcy at all.
It's not. It's exempt.
So they don't necessarily have to raid that entire retirement in order to pay the bills to avoid bankruptcy.
That's correct.
Okay.
Absolutely correct. That's why it's so important to come and see a professional as soon as possible.
Yeah, wow. Interesting.
A couple of quick questions. Hopefully the answers are quick as our time's getting kind of low. If I file for Chapter 7 bankruptcy, can I file again later?
Now, you can only file every 8 years on a Chapter 7 bankruptcy. If you filed a 13 and paid your case in full, then you have to wait 4 years. There are different rules and different time frames for what you've done in the past.
What happens if you start a Chapter 13 plan to reorganize, you pay the bills for a period of time, then you're unable to pay the bills because you lose a job, there's a divorce, something significant happens, medical bills, etc. Do you lose the benefit of what you have already paid? How does that work?
No, and you can convert your case to a Chapter 7 at that time. The court's very understanding about that, and also look at you. Look, you've tried, you've worked as hard as you can, you've been paying all this time. Look at all this money you've paid. Certainly, we're going to be as easy as we can on you through the Chapter 7 process.
How fast does the process take itself from start to finish with a filing?
Right. When you file a Chapter 13, you have your first meeting of creditors with a trustee within a month, and you start making your payments right away. And at the end of that period of time, then if the trustee agrees with how your plan is, it's going to be confirmed shortly after that. Then you pay for 3 to 5 years. If you file a Chapter 7, then you have a hearing within a month and a discharge with 2 months after that. So it's 90 days from beginning to end.
Before we get to our final thought, the one final question here. When will I be discharged from bankruptcy?
90 days after you file.
90 days.
So it's a pretty quick process.
Very quick process.
Another reason why you need to go get counsel.
You want to be sure you get it right, because if you don't get it right, it could go on for a long time.
Yeah. From both of you, just a final comment from you, Ted.
Well, I think your questions have pointed out maybe the most serious thought, and that is if you're in a financial problem, go talk to a professional right away. Quite often we see people come to us when it's too late. They've already rated their retirement account or made some bad choices as to what they thought was the right thing to do. Come get that free consultation and find out what your choices are. Like I say, half the people that come to see me never file a bankruptcy or don't file right away. So come get that free consultation and find out just what you need to do.
And I think that, from my perspective, is the key, the free consultation. It's worth spending the time and the effort to sit down with somebody to understand what your rights are. I mean, one great factoid or piece of information that people may not have recognized is you don't have to raid your entire retirement necessarily if bills are overwhelming in order to try and stay current. There may be some other options for you. Certainly, we're not proposing that everybody file bankruptcy and save the retirement, but the point is that's one piece of information that I think is helpful to help people understand kind of what their options are and to recognize you're not alone. Last piece of information very quickly, if you have an ongoing lawsuit, remember to make sure you tell the person in charge of your bankruptcy, because you may have to list that as an asset in your bankruptcy estate. We run across that quite a bit. When people fail to do that, we have to amend their schedule.
Some helpful information. Appreciate you both being with us tonight. Appreciate you joining us as well. We're going to wrap this up, but as we do so, ways for you to get in touch with the firm of Hollis, Wright & Couch. Find them on Facebook and Twitter, and we'll look for you next week right here on The Attorney.
Thanks for watching The Attorneys, sponsored by the law firm of Hollis, Wright & Couch.
Knowing your rights when facing mounting debt. Welcome back in to our final segment of The Attorneys. As we're into this final segment, I want to encourage you to go ahead and get in touch with us. We'd love to hear from you. Interesting statistics you guys always provide. A Harvard study reported that half of U.S. bankruptcies caused by medical bills, oftentimes all kinds of different circumstances resulting in the pressures and the screws being tightened financially.
Yeah, it's sad. Answer this for us, Ted. Do people lose everything in a bankruptcy, or do you have the ability to keep some things? I mean, how does that work? Because I think that's a question that people are always asking related to bankruptcy.
The bankruptcy code sets out exemptions that people are allowed to keep. However, states were allowed to opt out, and almost all the states did. So the exemptions that are allowed in Alabama, which are fairly low, is what people are allowed to keep. People ask this question all the time, though. Am I going to lose my home? Am I going to lose my car? If you owe money on your car and you stay current on it, then you're usually allowed to reaffirm that debt, continue to pay it, and keep your car. There's usually very little equity in a car. In a house, though, we have a different problem. If you have more than $5,000 per person equity in the house, and the court looks at that a little bit liberally, let's say there's $15,000 equity in a house, you'll probably be okay if it's owned husband and wife. But if you have too much equity in a house, you could lose it if you don't have somebody that can help ante up that difference to the court and reaffirm the debt. But a lot of people have to pick and choose what they want to do and what their whole situation is. Nobody wants to go into bankruptcy. But without the advice of a professional looking at your individual circumstance, it's hard to say what you can keep and not. All retirement plans are exempt.
Yeah, I was going to ask you about retirement and pension plans.
Unfortunately, we see a lot of people that haven't come to a lawyer soon enough, and they've raided their retirement account trying to avoid having to do anything, and then they come to see you, where if they'd come to see you sooner, they could have saved that retirement account.
Yeah, that's a good point. Let's stay on that just for a moment. What you're saying is, under bankruptcy, if they have a pension or a retirement plan in a plan at their work or that they've maintained, yes, that may not be subject to bankruptcy at all.
It's not. It's exempt.
So they don't necessarily have to raid that entire retirement in order to pay the bills to avoid bankruptcy.
That's correct.
Okay.
Absolutely correct. That's why it's so important to come and see a professional as soon as possible.
Yeah, wow. Interesting.
Yeah. A couple of quick questions. Hopefully the answers are quick, as our time's getting kind of low. If I file for Chapter 7 bankruptcy, can I file again later?
You can only file every 8 years on a Chapter 7 bankruptcy. If you filed a 13 and paid your case in full, then you have to wait 4 years. There are different rules and different time frames for what you've done in the past.
What happens if you start a Chapter 13 plan to reorganize, you pay the bills for a period of time, then you're unable to pay the bills because you lose a job, there's a divorce, something significant happens, medical bills, etc. Do you lose the benefit of what you have already paid? How does that work?
No, and you can convert your case to a Chapter 7 at that time. The court's very understanding about that, and also look, you've tried, you've worked as hard as you can, you've been paying all this time, look at all this money you've paid. Certainly we're going to be as easy as we can on you through the Chapter 7 process.
How fast does the process take itself from start to finish with a filing?
Right. When you file a Chapter 13, you have your first meeting of creditors with the trustee within a month, and you start making your payments right away. And at the end of that period of time, then if the trustee agrees with how your plan is, it's going to be confirmed shortly after that, then you pay for 3 to 5 years. If you file a Chapter 7, then you have a hearing within a month and a discharge with 2 months after that. So it's 90 days